order as well as the learned single. But in fact, the learned single judge records the statement of my learned friend, wherein he says that unequivocally we have given direction to the state authorities to release the amount. But kindly see the order of the learned single judge. He records that statement. Page 53. There is no question about now they going back on their word. Page 53. Kindly see page 53. He will not expect me to go to civil court and summon all 400 people. And what is the question I'm going to ask them? Did you eat that day or no? I mean, this is something which is.
What is the amount?
About
10 crores
10
is,
crores 81 lakhs is what they have sought for, my lord. 7 crores 45 lakhs has been paid to them.
Already paid.
We have already paid 7 crores 45 lakhs.
3 crores.
3 crores. I'm
No,
telling
man.
you.
7
No,
7
whatever it
crores
is, memo of
45 lakhs.
calculation will find.
I dispute that amount. We have paid 7 crores 45 lakhs. And they have claimed 10 crores 81 lakhs on the basis of the invoices. And without, my lord, the due diligence has been carried out. Audit has raised objections. Now to say that in a writ proceedings, I endorse this invoices, my lord, would be contrary to the law.
But
Second,
they-
your lordship itself.
With respect, learned single judge has not endorsed it. It is their deputy commissioner who has endorsed that invoice. And 6 years later, my lord, if he asks me to prove whether that person ate the food or not, it will become impossible for me. This has to be done on the spot on that day, which has been duly done by the deputy commissioner. These are all matters, my lord, where there is no evidence available. It's because of food consumption.
Now the difference is of 2 crores only.
No, it's not 2 crores, but
10 crores.
1 second. 15 crores is what was the claim made by us. They asked us to reduce it by 1 crore 45 lakhs. We did so. 13 crores was balance, out of which they paid 3 crores. 10 crore 81 lakhs is the balance.
Lord, according to us,
This is recorded by the learned
my
single
lord,
judge.
we have paid them 7 crores 45 lakhs, which I can place on record. Their writ petition
Not at the
claims
same
10 crores 81 lakhs. And that has been allowed. My lord, may I just pass on the judgment? Only I'm on the point where, my lord, this court has also taken in BBP Studios case that serious contractual disputes cannot be adjudicated. We are not shutting down the.
Here the
remedy of
bills
the-
are certified, that is it.
No, my lord, the difference is, we have a right by virtue of a doctrine of public trust itself. Have a duty to do a due diligence. Now, simply because they submit an invoice endorsed by one of the returning officers, do I lose my right to raise an objection? These are public funds. 10 crores 81 lakhs is being sought for on the basis of invoices which we have disputed. What prevents them from establishing this invoices, my lord? When I have the documents to show there are only 43 personals or 54 personnel in particular offices, how could they have supplied meals to 400 persons, my lord, on that day? If he says that numbers cannot be kept count of, then is that not a case, my lord, where it's a pure case of inflation? For mere asking, the amount has to be released to them. For mere asking. And what the learned single judge does, my lord, he endorses this invoices. That is the error, my lord, according to my humble submission, my lord, which could not have been done. Lord, that's why, my lord, the Honorable Supreme Court, by referring to a Chief Justice Neelay in a court, in US court, my lord, I have very few illusion about my own limitations as a judge. I am not accountant, electrical engineer, financier, banker, stockbroker, or a system management analyst. It is height of folly to expect judges intelligently to review 5,000-page record addressing intricacies of public utility operations. It is not a function of a judge to act as a superboard or with the zeal of a pedantic schoolmaster substituting its judgment for that of an administrator. So therefore, my lord,
Academically, it is very interesting.
Lords, there are plethora of cases.
English judgment.
There are
No,
plethora.
no, that, Mr. Counsel, it is very settled proposition and we lean towards it. That in contractual matters, the
Yes, my lord.
that's the consistent view.
civil
that-
remedy is the remedy. but
That's all, my lord.
then
It's
we
settled
have
in
to-
1952.
We have to go little deep in this case, whether that,
Yes, yes. That
whether it is
principle is
an
up.
My lord, my-
acknowledged bill or.
It was acknowledged, but I'll be in a position to demonstrate. Everything was acknowledged.
I read out at para
Retail International is what
page
the-
44, my lord. Page 44, I read it out. It's a matter pertaining to the
English decision.
English Chief Justice Neelay, my lord, of US court, my lord. Page 44, my lord. Para 44. Lordship will get it in words of Chief Justice Neelay. I have very few illusions about my own limitations. As a judge, I am not an accountant, electrical engineer, financer, banker, stockbroker, or system management analyst. It is height of folly to expect judges intelligently to review 5,000-page record addressing the intricacies of public utility operation. It is not function of a judge to act as a super board or with the zeal of a pedantic schoolmaster, substituting its judgment for that of the administrator. Now, my lord, there are two audit reports which we have placed. My lord, we have disputed. And the learned single judge, my lord, endorse 348 invoices.
How audit report can dispute it?
My lord, by verifying the attendance register, for example, my lord, your lordship
Can
may kindly
attendance-
take, I have definite records to show what are the number of personals. The work order issued clearly says that you will supply meals to my officers.
These are
I
all
have
for
a
the-
count of my officers. The invoice does not just states a figure and they expect us to accept
The
it.
first time being introduced, first time, neither before any authority, nor to response, nor before the single.
Because these
judge,
are
nor
disputed
For the
questions.
first time, they have invented all these things.
Lord, they're bound to
Really
answer.
unfortunate, not the state has to be more reasonable to us. But I have taken loan, surface notices have come to us. 2019 parliament election, and not, these are not definite contracts of building contracts. But they ask us to not put up CCTV camera, provide cars, food for all the persons. I can't count and give. But when we open a food stop, there are sort of para volunteers who come and consume. In fact, I have letters issued by the deputy commissioner who certifies that only certified people cannot eat. There will be others who will come and eat who are not engaged for the day. All of them should be provided food. Police personnel, all that is there. Lord. In fact, he has certified it.
No, that
And the
statement
state
itself,
comes up Lord, with this theory today. It would-
You filed the petition belatedly?
Not belatedly, Lord, we have gave 4 representations when there was
5 years.
2019 election, not 3 representations we gave. They did not 2020. 2020, we-
Only 20 you filed.
23, my lord.
not 23. 23.
23, my lord.
23 we filed.
23, my lord.
So 5 years later.
5 years down.
No, my lord, kindly see the representations. We
No,
filed
your
representations,
representation does
meetings-
not extend.
No,
the
the
period of
meetings were held,
limitation.
I'm sorry, meetings were held. They were assured of the payment. That is what we pointed out. Chief Election Commissioner also intervened. It was only at last resort we approached the court. That will
All
be our
that,
position.
my lord, my only humble request is, even by virtue of.
There are plethora of cases, my lord, where BBMP, my lord, contractual money is not paid. Courts, my lord, have been approached. They have taken time to release the amount and they have released. This is one such case. But I do not want to go back the reason why they are so opposing so much in this matter. There seems to be, anyway, my lord, I do not want to,
Lord, it's,
no,
There's
let
a-
us not get into that.
there's a saying, my lord, one should not cheat. But it's important, one should also not get allowed to be cheated. By virtue of this inflated invoices,
You are receiving funds from the election.
Election Commission of India.
funds are from them, my lord. But we have taken up a ground that management of public funds is an essential
Nothing to do with that.
work. We, by virtue of due diligence that we are required to carry out, it's a public fund, my lord.
But they are not disputing the entire.
They have, they cannot also, my lord,
May I
because
submit
it is my tender, man. Money is to be paid by them,
Yes.
but tender has been issued by the first.
So, Lord, in fact,
by the
Election
second.
Commission of India has given a direction to release the fund. Lord, kindly see the order of the learned single judge. There is a communication issued. Please release the funds because nobody will trust us again. Again, 24 election, Lord, we were called upon and we were given the contract. 24 election, if we had cheated them, so called that statement. 24, we were given the contract, again we performed.
Lord, what election may I submit, what Election Commission of India has said, my lord, Chief Electoral Officer of the state. Lord, he said it is an internal communication between the Chief Electoral Officer and the Deputy Commissioner and the Chief Commissioner BBMP. Lord, it is at page number 864 at volume number 4. Lord, he said after the interim order,
Volume number 4.
volume number 4, my lord, page,
Did you file your counter?
no, my lord, I have not filed in the counter in the writ petition. My lord, this is the communication produced by the petitioners.
Would you like to file counter here?
My lord, Lordship, our stand is very clear, man.
Where is that?
It is in, my lord, 840,
We want your stand from the record.
please.
From the decision of the Election Commission.
Volume 4.
Please, my lord, volume 4, page number 864, my lord, it begins.
Page
864, my lord.
840.
Translated copy is at 866,
864.
please. My lord. My lord, translated copy is at 866, my lord. May I request after, Lordship, may kindly turn to page number 867. What is the relevant?
No, kindly see 866, last sentence, kindly read that. That is where the direction is issued.
Lord, may I read in the middle of the page, my lord, after the reference? Lord, 867, as described in the above mentioned details regarding the payment of the outstanding bills related to the cited cases, in the meeting held in this office on 23/9, it was directed to review the pending payments of the said cases at your level as per the rules and take appropriate decision and action accordingly. Lord, what we said is that to review the bills at your level and take action as per law. It is not that, my lord, we will release the fund. Lord, election commission is
But
do
not
not
only
have
that,
the
but they
independent fund.
accepted, no, I'm sorry, they accepted the order of the learned single judge in the interim order. That is what the election commissioner says at
Lord, we
866,
we
last
said
sentence.
it's a- we review the order, review the pending bills and take action at your level.
This is dated 12th of April 2024. And we have reviewed. The regional commission, office of the regional commissioner has reviewed. The office of the chief election commissioner has reviewed.
It is
And
not,
they have said these
reviewed.
are purely inflated bills. For mere asking, this amount is going to be released. No accountability with number of people who are fed.
There is no direction, that the translation is not correct. It is not review. Please take a decision, is what the Kannada word says. Parishilisi sukta tirmana kaikolbekante, there was a direction. In fact, they say High Court has directed, we require to comply with it. Please release the amount. This is the word. At page 866, last few sentences are clearly shows that they have accepted the order of the learned single judge. Both the interim order as well as the learned single. But in fact, the learned single judge records the statement of my learned friend, wherein he says that unequivocally we have given direction to the state authorities to release the amount. But kindly see the order of the learned single judge. He records that statement. Page 53. There is no question what now are they going back on their words. Page 53. Kindly see page 53. The election commission has clearly indicated that the issue should be sorted out within its head. After the interim order supra was passed by this court, the learned counsel for the election commission submits that the commission has directed release of the amount early. And now, even after the interim order was passed, the state is sticking to its stand 5 years ago.
May I submit, my lord, that statement?
No, he cannot.
My lord, now with that statement, my lord say that is the communication my lords have seen at page number 864, my lord. That is the reference. After the interim order, my lord, after the meeting, the communication is at 864.
64. Volume
My lord, reading further in the same paragraph.
Canada. And now Lord side. Satisfied. But it has to be supplied. Additional. And now that lordships are on that word, may I request also?
Your synopsis will decide it.
Yes.
Yes.
May I just also take your lordship once through the additional affidavit that I have filed?
No, but
Just to
before that,
point out-
before that, since what they are trying to introduce dispute, but I have to meet this so-called ghost of a dispute they are raising before your lordships. Kindly see page 49. What kind of not objection they have raised it? But can this be something which it has to be decided by civil? Page 49, not internal page 21.